All right, good morning, everyone.
Morning.
Judge Jared Smith, let me just introduce our panel here. Judge Joshua Mize to my right, and Judge Brian Lambert to my left. And counsel, if you could go ahead and state your name and let us know how much time you want to reserve for rebuttal. And for the record, this is case 23-1940 Walmart versus Dorothy Nguyen. Thank you, counsel.
Good morning, Jack Ryder on behalf of Walmart. I'd like to reserve 5 minutes for rebuttal.
Okay. Fair enough. Let's go ahead. That's all ready. Okay, you may begin, counsel.
Thank you. Again, may it please the court. Again, my name is Jack Ryder on behalf of Walmart. Your Honors, in this case, the trial judge clearly abused his discretion in how he applied the Binger analysis, the Binger versus.
So counsel, you're doing the same thing in your oral argument that I thought was interesting in the brief, which was both parties operated under the assumption that we're going to read Binger out the same way the other 5 DCAs read Binger. And I'm not sure why anybody made that assumption.
Well, Your Honor,
can you give me a Pedroza analysis on Binger?
Let me start with the, I'm sorry, Your Honor, what was the question?
So in Pedroza v. State, Justice Lawson told us how to read a case, right? How to read a holding. And he said that the holding consists of the decisional paths that are actually decided based upon the facts of the case and lead to the judgment. So in Binger, all the other DCAs basically said that the holding of the case was setting forth this 2-part test for what courts must do before they exclude evidence or testimony that was undisclosed. And I guess as I reread Binger preparing for this, I'm not sure how we can say the statement in Binger about what to consider before excluding evidence was a holding when in Binger, the Supreme Court found that the trial court improperly allowed undisclosed testimony that should have been excluded. So the decision there was that the trial court should have considered the prejudice to the opposing party before allowing undisclosed testimony in, and considering that prejudice should have excluded it. The Supreme Court did not find that the trial court improperly excluded any testimony. The Supreme Court did not decide that the trial court in Binger improperly excluded undisclosed testimony without considering prejudice. That just wasn't what the court decided. So if I'm going through the Pedroza analysis on Binger, the issue actually decided was that the trial court should not have allowed in undisclosed testimony without considering prejudice to the other party. And the facts of Binger were that the trial court allowed undisclosed testimony to be presented to the jury when it should have excluded it based on prejudice to the opposing party. So if the facts of Binger and the decision of Binger was about undisclosed testimony that was improperly allowed without considering prejudice to the opposing party, how is anything the Supreme Court said about what a trial court needs to do as a predicate to excluding testimony not dicta?
Well, Your Honor, it's a very interesting perspective. And I say that because, quite frankly, I've not heard a court call into question this specific analysis of what we have come to characterize as the Binger approach. The way Your Honor identifies it and discussing it from the Pedroza, the way Your Honor identifies it actually supports reversal here, because what it suggests here is that the court should not examine it from this narrow window of whether or not it was undisclosed or whether or not it was in fact prejudicial, but should examine it from the perspective of whether or not it was new testimony. If we're looking at this from the perspective of whether or not, number one, starting from the perspective of Your Honor's point is, should Binger even be applied in this instance? Then I would start from the premise of, although I suggest to the court that there is sufficient.
Tell me why the other DCAs were correct to read Binger that way.
Well, I think Your Honor,
go through the Pedroza analysis.
Well, number one,
if I'm wrong about how I'm reading Binger, the other 5 DCAs were right. Tell me how.
Well, Your Honor, I would only start from the premise of the fact that many district courts over the course of several years have.
I'm not interested in how many. I'm interested in whether they're right.
Well,
I've just told you how I'm looking at Binger. Tell me why I'm wrong.
Sure, Your Honor. I'm not suggesting you're wrong. I guess my question, not a question, but my comment is, I'm trying to understand how that will impact the analysis in this case. And the reason I say that, go ahead.
The reason way of impact is if the holding of Binger was you can't allow in undisclosed testimony without considering prejudice to the opposing party, then all we have here is undisclosed testimony that wasn't disclosed by the deadline that the court didn't allow. Court enforced a pretrial order, and something saying you have to consider prejudice before allowing it would just have no applicability here. And if you go on later into Binger, there's, and I'll concede this is dicta as well. But the court literally says some courts, some circuits have strict trial orders where they do not allow in any undisclosed testimony by certain deadlines. This holding does not affect those trial orders. Local courts are free to enforce them strictly. I mean,
So the
So I-
reason, I guess the reason why, and I'll certainly admit, Your Honor, since the trial court applied Binger and both sides have looked at Binger as the presiding, understanding it's not, and I understand the court's, Your Honor's perspective on this, understanding that it's not necessarily that it's dicta and not necessarily a holding. I have to go back, with respect to this case, because we don't have an undisclosed opinion. And I think I have to start from that premise. Let me say this. First of all, why do I think that the Binger analysis has been applied correctly? Quite frankly, I think that the way that courts have applied what we characterize as the Binger analysis is a natural offshoot of the concept of undisclosed testimony, because one should, if testimony is in fact undisclosed.
natural offshoot to me is basically saying it's a logical extension.
Something like that, Your Honor, yes.
Do you think I've mischaracterized whether or not that was actually the holding of Binger?
I do not think you've mischaracterized the way you framed the holding of Binger.
Okay.
I do not.
So do you concede that under Pedroza, if we apply Pedroza to Binger, the holding was consider prejudice before allowing in undisclosed testimony?
I think that's accurate, Your Honor. But in this case, it doesn't change the analysis. And so I guess I'm going to come back to this case. And let me say two things. Number one, the way you've identified Pedroza in terms of the holding and what I characterize as the logical or natural extension of Binger, as other district courts have applied it, and as the trial court applied it in this case, and as both sides seem to have applied it in their analysis, I think supports a reversal here. But even if we put Binger aside and we narrowly examine it under Pedroza and the concept of, number one, prejudice, number two, whether or not it was even an undisclosed opinion, I think the principal argument here for why reversal is warranted is because this was not an undisclosed opinion. And I start from that perspective.
Counsel, if I may, and of course, we've read your briefs, as you can tell. What you're about to argue, show me how that was argued to the trial court, because as I'm looking at the transcript, page 180 of the trial transcript, 2307 of the record, when defense counsel was responding to the court's the inquiry on this Binger analysis at the time, he said, Your Honor, I don't know if he goes far as to directly contradict his prior testimony, but I think the bigger issue here is prejudice anyway. I mean, isn't that a concession?
No,
Didn't defense counsel essentially concede? But and if he didn't concede, where did he ever argue what you're about to argue to the lower court?
Well, first of all, in that entire colloquy, the back and forth, and I know exactly where Your Honor is looking. I can pull up the transcript and we can go through it.
Sure,
But
we've all read it.
okay, well, then Your Honor has seen that he goes back and forth. Counsel argues, first of all, he says it's not undisclosed. He does talk about the fact that there was testimony, two things. Number one, he talks about the fact that Dr. Odemark referred to the lower back and the lower back issues and this existing nerve issue. He talks about that. And if Your Honor, as Your Honor has mentioned, you've seen the transcript.
I'd prefer, I mean, if you're going to, rather than paraphrase it, if you want to quote to me the sections you're talking about, because what I'm looking at is a very, it's what I would characterize as essentially about a 2-paragraph argument that was made by defense counsel.
Sure.
And I just don't see it.
But yes, Your Honor, I know exactly what you're looking at, but then he says, I would like to proffer the entire deposition. And he says, again, I don't have the entire transcript in front of me and I can start pulling up excerpts, but I'm afraid I'll run out of time if I do that. But I want to make clear, if Your Honor looks exactly at what Your Honor is referring to, where he says the bigger issue is prejudice, he then says, I want to proffer the entire transcript. And then you'll see in the colloquy back and forth, trial counsel talks about the fact that if you look at the entire transcript, which he then proffers into the record, he talks about the fact that there is, in fact, the
It's incorporation by reference.
well, it's incorporated by reference, but it's also, but it's two things. I think it's important, number one, first of all, if we look at whether or not this was in fact undisclosed testimony, Dr. Odemark repeatedly talks throughout his original deposition about the fact that this was a lower back issue, that it was a higher nerve issue, and that was number one. Number two,
I think you're right. I read the transcript of the deposition, and he did do that. But then the opposing counsel tried to pin him down and said, but basically, bottom line, are you going to testify that the pre-existing back condition was the cause of this pain? He goes, no, I'm not.
So here's the answer to that. And I understand that that's what plaintiff has capitalized upon. First of all, I believe it has to be read in paramateria. This is not simply a matter of, well, tell us your final conclusion, and here's the reason. The defendant does not have a burden of any sort of proof. The defendant, we as a defense, we don't have to demonstrate to a reasonable degree of medical probability that the back was the cause of the nerve pain. We only have the obligation to identify evidence to provide and support an alternative theory. Multiple cases support that concept, and plaintiff hasn't challenged that principle. The bottom line is that we and I'll just note, cases like R.J. Reynolds versus Mack and Woodruff versus R.J. Reynolds, which say that it's not our burden of proof. So when the Dr. Odemark said, I can't say with certainty, I don't know if it's the back. I just know it's not the fall, but I think it might be the back. And we have this litany of medical tests and history that refer to the back. And I want to make clear, I don't want to lose sight of the fact that this is all about whether or not the trial testimony of Dr. Odemark was an undisclosed opinion. And to be clear, it's undisputed that there were new medical records that were produced.
Well, that goes to the reason it might have been undisclosed and whether there was a justification, not whether it was undisclosed, right?
Well, that's a fair point, Your Honor, but to be fair in terms of how we assess this issue.
I get it. I'm gonna have questions for your opposing counsel
course.
about that.
Sure,
But it's about the standard of review here, because I understand, typically whether or not to allow in, evidence is an abuse of discretion. And identifying whether this was a change in testimony, we're looking at two deposition transcripts. This wasn't live testimony in court. It seems to me we're in the exact same position as the trial court was. The trial court was not better positioned than us to read two deposition transcripts and compare them. So it's a little bit different than your normal, admission of evidence live in trial, where we would oppose abuse of discretion. Trial judge is
I agree
reviewing
completely.
evidence.
No,
So is there anything we can do with that? Is there?
Absolutely.
I mean, what would be the path to a different standard of review there in terms of on the issue of deciding whether this was in fact a change of opinion based on the two transcripts?
So I'll say this. As it relates to whether or not this was a change of opinion, this court stands on equal footing as the trial court for review of that issue. Now, whether or not the trial court correctly excluded this evidence is an abuse of discretion standard. But in terms of, the abuse of discretion standard is a little bit variable in and of itself.
What's the authority for breaking out those two issues? Because I totally agree with you about abuse of discretion, about, admitting or not admitting and evaluating prejudice, but evaluating the two depositions. It makes sense to me we'd
Sure.
be in the same position, but it's still ultimately evaluating, admissibility of evidence. Is there some authority that says we can look at that on a de novo basis?
There is authority that says, and I'm going to apologize in advance because I don't know that I'll remember the case name, but I do know that there's authority that stands for the proposition that when transcripts are provided to the appellate court, that they are an equal ability to review, then they can make a determination. Your honors can make a determination as to whether or not evaluating two transcripts together, whether one is in fact new testimony, quote unquote. Now, I don't have off the top of my mind a case that explicitly supports that proposition, but I do know that when this court is looking at a cold record, but I do see a dichotomy there, because I still think the ultimate decision about whether to exclude or not admit the evidence is still subject to an abuse of discretion standard. But if the trial court's decision, I'll just say one thing, Your Honor, if the trial court's decision is based on a misapprehension of law or a misapprehension of the evidence, and that might be a way to assess that this is really a de novo standard on that principle, to answer your question. If this court were to say, for example, and I think we can say, that evaluating whether or not an opinion is undisclosed in the sense that does the deposition differ from the trial testimony, I think because of the equal footing, this court can evaluate that de novo, because it's almost like the applicability of the evidence.
All right, so counsel, assume, respect to the standard review that we decided against you on that issue, it was an undisclosed opinion. And assume Binger didn't exist, or we decided it wasn't applicable to this case.
Sure.
Would the posture have been here, hey, we got documents late, and since we know we can't change our opinion after the deadline, we're not going to be able to get it in, Binger doesn't exist, we need to move for some type of extension, saying, hey, we thought we served a discovery request in June. They didn't respond. They forced us to file a motion to compel. They didn't give us the documents that we need to change our expert's opinion or update it. until the day before discovery and to give us another 10 days on the discovery deadline or 5 days. Wouldn't that have been in order to actually comply with the deadlines rather than rely on Binger, what your client would have needed to do?
I don't think so here, Your Honor, because this was not a case. So, well, again, I don't believe it's undisclosed. If the courts were to determine that this trial testimony was in fact materially different than the deposition, and therefore to deem it to be undisclosed, then I do think that any time the trial court's evaluating whether or not to admit or exclude evidence, there is inherently a prejudice component.
No,
So,
there's a prejudice.
Counsel, you're in your rebuttal time. So if
Understood.
you want to reserve the rest of your time, you may do so. If you want to answer.
Sure,
There's
if I'll
a
answer
prejudice
it.
component because of Binger. Okay, so imagine you're in federal court, right? Imagine there is no Binger, and all you've got is a trial court deadline saying September 27th, any and all discovery, any and all opinions, use them or lose them, right? I mean, so
Sure.
there without Binger, there is no inherent prejudice component that flows for Binger, and I'm questioning whether or not that applies. And if you were in federal court, I think what you would have done was scramble to file a motion saying, hey, they gave us late discovery, we need another 10 days. And then the trial judge would have been able to evaluate that and said, yeah, you gave them discovery the last day. They need 10 days to evaluate it and update their opinion.
So to answer that, if we're looking at it from that perspective, Your Honor, then the plaintiff completely waived this issue because they did not object contemporaneously at the time of Dr. Odemark's trial testimony when he provided this opinion. So if we're looking at it from that narrow window, Your Honor, then the reversal is clear because they failed to object contemporaneously. And if we're going to look at this issue through that narrow window of what if we were in federal court and the Binger analysis didn't apply and Dr. Odemark was sitting in the courtroom and started testifying, plaintiff missed their opportunity to object. And therefore the testimony came in. Now, I also have, before I close on this, I do also have an argument about improper closing comments. I believe that is an independent basis for reversal, which I'm happy to answer any questions or to discuss more fully on my rebuttal, but I want to make clear that we advance that as an additional basis for reversing. Thank you,
Counsel. All right, Counsel, you may proceed.
Good morning. May it please the court. My name is Brian Lee. I have the privilege of representing Dorothy Nguyen as the appellee in this case. I do want to talk about the question that Judge Mize has brought because I knew it was coming my way. When we look at Binger, yes, Binger is talking about a pretrial disclosure of witnesses. It's a list. And I think one part of it when we're talking about how we look at Binger and how we've used it in our appeal is still key, and it is part of Binger. And I'm looking at where the court after the sort of beginning colloquy says that in order to resolve the dispute in this case, it's not essentially plow new ground in the field of civil practice. Existing rule 1.200 of the Florida Rules, Civil Procedure, provide an adequate framework when supplemented by a faithful adherence to the notions of discovery which underpin civil trial practice and the good judgment of Florida's trial judges. Now, Binger later on goes through the 4 approaches that were at that point, and there was discrepancy amongst the DCAs of how to do it. And some said, well, you have to give impeachment witnesses only. Some said you have to do both. And what Binger said later on, the Binger court said, the first 3 we are not going to use, and we're going to use the 4th, which puts the discretion within the trial court. So Binger is very clear that when we're talking about issues of witness disclosure, whether it was disclosed correctly, they obviously, as Judge Mize says, gave deference to a particular judge's trial orders. It's very clear that the underpinning, the main focus, and I think the main holding of Binger is that it's under the discretion of the trial court.
Well, let me ask this. So
Yes.
this witness was deposed the Friday before trial
Correct.
in lieu of testifying at trial.
That's correct.
Okay. So let's say that didn't happen. Let's say the defense had called this doctor at trial.
Right.
And so he's near the end of the trial. You've already put on, your side's already put on testimony about why this is the nerve damage, et cetera, is causally related to the fall.
Mhm.
And so this doctor comes in at the end of the defense case saying, I've now gotten these new records from you guys on the last day of discovery. I mean, we wouldn't say it like that, but in essence, that's what's happened. And in my opinion, it's not causally related. I never saw it before. You know, I had very serious questions before because there was no records from the ER immediately after the accident that suggested nerve damage. And now these late disclosed documents that just confirm this. You've not been prejudiced at all. You were aware, I'm not picking on you, but I mean, your side was clearly aware what was going to come down the pike from the defense side. They're not going to call that expert to say, and oh, by the way, we agree with all the plaintiff's experts. She was injured because of this. We wouldn't be having this late disclosure, undisclosed discussion under Binger. Here's just a trial witness. Why is it not an egregious abuse of discretion by the trial judge to basically cut the defense of Walmart by excluding their expert witness?
But well, number one, I would say they didn't exclude their expert witness.
Well, excluded the critical testimony. I mean, they didn't call them to say, well, did you look at the records too? Yeah, they're nice records, etc. They called this doctor to say, and your opinion is this, which everybody understood that's what was coming down the pipe. So how is it not just fair to say, and your side preemptively addressed that with their experts correctly. I applaud your side for doing that. That's what you should do. Okay, so why is it not just both sides have their experts, the jury's here to listen. Go ahead, judge, just let this fella give his one-line expert opinion, you know, crescendo here, and off we go, and then we wouldn't be having this discussion at all.
I think we would still respectfully still have the discussion, because
well, if you would have won and got the same $1 million, we wouldn't be having this discussion.
True, but
okay, so we would.
But exactly, but we are talking about because I think that you're making a distinction between, okay, well, this was done pre-trial and this was done during trial. I don't think that there's cases that make that distinction.
That seems to be it's a late disclosed. I mean, it's not a, you know, like
it's a late disclosure
about an undisclosed witness. This guy's been disclosed from the get-go. Binger's been expanded to say an undisclosed opinion.
Correct.
And that's what the concern is. And then they get into the prejudice discussion.
Right.
And I don't see how your side is remotely prejudiced by this. I mean, you can't tell me that your side is sitting there saying, well, oh, I have no idea what's going to be said. And in fact, it's even more egregious in my view, because you guys knew Friday before what this doctor was going to say. You didn't move to exclude it at the start of the trial so that it perhaps could be addressed. Your experts could have had the ability, and maybe they were advised as to what the defense doctor said, so that they could that could be facilitated in their own direct testimony in the plaintiff's case in chief. So I mean, I'm at a loss as to, you know, Binger or no Binger, federal court. I'm at a loss as to why this expert would be excluded. I mean, if Walmart had numerous other experts, you'd say, well, you know, you didn't get this expert, but you had two other good experts, so it's just the way it goes.
The causation opinion Dr. Oddmart gave, he was able to give opinions that this crash did not cause the injuries.
Well, then why are we here?
Yeah,
because
not able to give the primary opinion they want, which was the nerve pain was caused by the prior back injury.
That's
right. When your clients testified that it was not, your experts testified that it was not caused by the client back injury. So by the prior back injury.
Right.
They don't tell us they didn't exclude a key opinion.
No,
they clearly excluded a key opinion.
No, I'm not saying that they didn't. I'm certainly that the trial judge excluded an opinion that the defendant wanted. Absolutely.
The spot. I mean, because then there was a double downing in the closing saying, and they don't have any evidence to talk about this. I mean, that just seems to be a snowballing effect.
Which was unobjected to, I would mention. But when we're talking about, look, you know, Binger or no Binger, we are talking about trial judges that do discovery orders. And if we look at Binger just purely as to the words in the opinion, Binger court, the Florida Supreme Court was very clear that they are going to give trial judges the ability to either keep witnesses or not, based upon things like their discovery orders, things like discovery deadlines.
Yeah, so I find that persuasive. So I want you to respond to your opposing counsel's point. This wasn't done live at trial. You all stipulated that you were doing a deposition to perpetuate trial testimony.
Right.
Right. And there was no objection at the time of the testimony.
It's true.
So we had a stipulation from both sides that this is trial testimony.
Right.
We have the testimony given with no objection whatsoever.
Mm-hmm.
Tell me why you didn't waive the objection.
Because you don't have to give, because the only objections under the rules that you have to give in depositions are form objections.
No, but this was a deposition where the parties stipulated that this is the trial testimony.
Correct, but there is no distinction in the rules. There's no rule distinction between quote trial testimony and regular deposition testimony. It's just deposition testimony. So there.
Well, let me following up with what Judge Mize was saying earlier. Okay, so you have a deposition that's coming in to be used at trial. Everybody understands that's what's going to be there. We're not just doing another discovery deposition.
Mhm.
You don't object to that or what is said there because you're saying, here's my reasons why you don't object.
Mhm.
Okay, so the defense, you know, part of Judge Mize's discussions this morning is, why didn't the defense move to continue if they knew that this wasn't going to be allowed because it violated some pretrial order? They had no reason to do that. They thought it was a deposition coming into evidence unobjected to by the opposing counsel. And then when they are in their defense, lo and behold, their primary dispositive opinion on causation is excluded. And then it's doubled down in closing argument as to, look, they didn't have anything that shows that's contrary to our plaintiff's experts. How is that not a fundamental? I mean, I won't use the word fundamental. I'm on another tangent. Well, how is that not a serious reversible error that just the unfairness of the overall tenor of this trial? I know that doesn't jive with
I understand.
precise language.
I don't want to hit you with multiple things, but when you
Sure.
respond to that, keep in mind, it's not just that your client, your side, your trial counsel did not object when the deposition was given. They then let the other side do their opening, right? So they didn't file a motion over the weekend. They didn't come in before the jury was sworn and say, hey, judge, we've got an issue we need to raise. They let them give their opening, at which they then said, we're going to have this expert testimony. And then after they'd given their opening, then objected to the expert testimony coming in, leaving them having made a promise to the jury that was then broken by order of the trial court. And we all know when you make a promise to a jury, you don't fulfill it. It's very unhelpful to your case.
So I will try to answer both questions here. There, at some point after the deposition of Dr. Oddmark was taken, there were deposition designations that were done by the defense. When those deposition designations were done, the plaintiff objected to that testimony. Now, I'll say candidly, when that was done, when the defense did their deposition designations, I'm not looking at the record right now. I actually don't know whether it was right after it, whether it was after their opening and then they did their designations. I don't know the timing of that, but we know at some point in the trial, there was deposition designations that were done and there was objections by the plaintiff.
You know that your trial counsel sat at plaintiff's table while they gave their opening and told the jury, we're going to bring this in, and said nothing, correct?
That's true. There was no objection to it, but I don't believe that, frankly, I think that's moot. If a defense attorney, frankly, or a plaintiff attorney says, jury, you're going to hear this testimony from such and they're going to say this, or she's going to say this. I think we all have learned that that's to your peril, because you don't know whether that testimony is coming in. And so that is something that is not a fault of a plaintiff lawyer for if a defense attorney says that, and then later on can't get that evidence in. I can't think of a case ever that has said that, well, a plaintiff, you should have actually said something because maybe they weren't going to get that evidence in.
Well, I think that's a little different contextually. I mean, you make statements of your opening statement that you're going to present this and this and this kind of evidence, and then the witness never shows up or something like that for whatever reason, and the case plows through, and what you promised before didn't occur.
Sure.
It's contextually a lot different here. You've got a deposition, unobjected to deposition, that they're going to read or present into evidence, and they tell the jury, you're going to hear from this doctor right here. And then they start doing that, and then all of a sudden the rug is pulled out from them under a Binger analysis that this is unfair, that it's such a difference of the opinion, and it's materially prejudiced a plaintiff who's already presented testimony that contradicts the expert testimony from the defense. So you've already presented to the jury, hey, here's our causation damage experts who are telling you that this nerve radiculopathy is related to this accident. So you're all not prejudiced at all. You put on, it's not like you had no experts before and all of a sudden this came up and you have to scramble and rebuttal. So,
Sure.
you know, Binger or no Binger or revisiting a Binger or whatever happens post this oral argument, it still strikes me as just you sort of fundamental, but there's something wrong here.
Well, and here's why here's why I respectfully disagree, Judge Lambert, is that number one, they knew that it was objected to. This wasn't a situation where they did deposition designations. There's no objection at any time. And then literally when they're about to do it, it says, oh, by the way, Judge, we're now going to object
But
to
you
that.
said you didn't know when the designation.
I didn't know that, but I definitely knew
Now
before
you're telling us that you know they happened before opening?
No, I didn't. I'm not saying that. I'm saying before that testimony went in, they knew about it because they argued in front of the judge. Prior to that, the designations were argued prior to with the judge. So this wasn't a situation. This wasn't an on the fly while they're in the middle of a video deposition, all of a sudden saying, "Oh, by the way, we're going to object now." That did not happen. And so, but then when we come back to the primary reason why the trial court did what the trial court did, found it was a new opinion, and even if you just disregard everything else, prejudice, anything, the trial judge has the ability, knowing everything in the case, to determine whether that opinion comes in or not. That is part of the discretion to a judge.
Wait a minute. So
Okay.
you're reading depositions.
Correct.
Okay. And so I think Judge Mize alluded to earlier with your opponent. So we're looking at the same things that the trial judge is looking at, right?
Sure.
And so we can evaluate whether it's a quote material change in the testimony.
I think at the standard, I do not believe that the standard is de novo. I think even if you look at the wording of Binger, even if you look at not even Binger, this issue about Dr. Oddmark is an evidentiary determination. Evidentiary determinations by cases from everywhere, including the Florida Supreme Court, says that is an abuse of discretion standard, period. And the only time it's not a non-abuse of discretion standard.
I'm talking, you need to stop.
Oh, okay. I'm sorry.
All right.
I was.
So if I'm on a motion to suppress in a criminal case, and
Sure.
we're looking at the video, just the video of the events, and there's no testimony about what I interpreted.
Right.
You're saying that we as an appellate court would defer to any factual findings the trial judge made from observing the video, and that we couldn't say, no, that's not what happened. We disagree with those findings?
No, that's not what I'm saying.
Okay.
Because you're talking about a situation where a trial judge made factual findings of the video shows, just for example,
Right.
the video shows that this was a green light and therefore
We're not bound by that.
and then you look at the video and it's a red light.
Right. So when I'm getting back to the deposition.
I understand that.
So I'm reading the deposition. This is what he said.
Correct.
I'm reading deposition number 2. This is what he said about
Mhm.
the causation. Why do we defer to the trial judge's findings about that if we're reading the identical documents?
I think
He's not making a credibility determination
Sure.
of that doctor.
Right.
He's reading it and says, I have now found that is a materially different opinion. Therefore, it's unfair to the plaintiff. I exclude it.
yeah, I understand what you're saying.
Okay.
I think that if there's I have to come back to the standard of review.
What if the
And
transcript's
this.
right? Counsel, there's 2 issues here, right?
Right.
There's deciding whether there was a change in opinion,
Sure.
and then there is deciding whether to allow it.
Right.
And I don't think anybody is disputing that whether or not to allow it is a discretionary decision. Evaluating whether it's different or not,
Right.
we're looking at 2 cold transcripts. So imagine, for example, that the transcripts were just identical. That expert gave the exact same
Right.
testimony, word for word, at transcript 1 and transcript 2. You're telling me we look at that and say, well, it's discretion of the trial judge determining whether they're different. He said they're different, so we've got to defer to that.
No, sure. I understand what you're
Acknowledge
saying.
that distinction in your argument between the admission of
Right.
the evidence and the evaluation of whether there's, a decision to even make about whether there's been undisclosed testimony.
Yeah, and admittedly, I'm sorry, I didn't mean to cut you off. And I apologize for cutting you off earlier. There are situations that I know, and of course this court knows, where a trial court, if they make a factual finding within an order, then it's pretty rife case law that says that this appellate court can then say, well, no, that's not really that factual finding has no basis in the order, in the record whatsoever. But that kind of standard, when a court is looking at findings that are made by the trial court, it doesn't say that an appellate court sits under the de novo standard, meaning that they give zero deference to the trial court. What it says is that if this court were to find that the factual findings of a trial court in its order have no basis in the record, it can say so.
So are you saying now that it's competent, but I mean, the standard you're describing is competent substantial evidence? Are you saying
there is a different standard for when we're talking about, now we aren't talking about that situation, just to be clear. That situation is when there's an order, and we typically see it when there's orders granting new trials, and the trial court puts in a factual finding that said this witness said this and
that's
this.
a completely different situation.
No, I
We're
understand.
talking about two cold transcripts.
That's what I'm saying, that's why I'm saying that there is a different standard in this case.
Let me ask you
Because we're
about-
talking about an evidentiary determination.
Let me ask
That
you
was
about the
done.
timeline here, because the way you characterize it in your brief
Sure.
is that they failed to disclose this new opinion to you, and they sprang it on you the day before trial.
Yes,
And that seems like a real stretch to me. They didn't get the documents until September 26th. They requested them in June. Your client blew the deadline. They have to file a motion to compel. Clearly, your client felt it had merit because they then produced the documents months late, the day before discovery ended on the 26th.
Right.
The deposition was 11 days later.
right.
Obviously, the doctor had to take some time to review the documents before forming the new opinion. How much time could they have possibly had this new opinion before the deposition, such that it's fair to characterize it as them having sprung it on you unfairly?
Well, we don't
And
know.
I guess since the answer is obviously not very long, was that a fair statement in your brief to say that they sprang it on you at the last minute, or was that an unfair statement?
I think it's still a fair statement, and here's why. The context of, because we're talking about medical records, and there's this allusion to medical records that the doctor reviewed, new medical records. These medical records were not records that were pre the incident that happened. They were medical records of ongoing treatment with that my client had, Miss Wynn had. And when we look back at Dr. Oddmark's question and answer that we put in our brief, when he's asked whether the pre-existing back problem was the cause of her current nerve problem in her right ankle, he doesn't talk about what she's going through now, the treatment she's going through now. He says, if she had a long-term nerve problem here, I'd expect some other issue to be going on that she would have been treated for, or had numbness and weakness or something like that. She didn't. So his testimony in the deposition was clearly related to what he thought, if this back condition that was a decade prior was causing it, she would have had this ongoing thing.
So are you saying that the new opinion was not related to the new records?
No, well, actually,
You didn't argue that in your brief.
No, I'm not, but we're talking now about medical records and we're asking questions. The medical records that were supposedly the impetus for the new opinion didn't relate back to what his previous opinion was.
Any further questions from the panel?
Your Honor, I would ask that this court affirm the trial court. Thank you so much.
Thank you, counsel. And counsel, we did give your opposing counsel an extra minute, so we'll give you that courtesy if we need that extra time. Okay,
Thank you, Your Honors. So let me start with this citation, referring to the fact that when it's Wilson versus State, 274 Southern 3rd, 549, 5th District decision. It's one of multiple cases I was able to find that talk about the fact that when findings of fact are mainly based on videotapes or transcripts as opposed to live testimony, the same level of deference does not apply. Citing Almeida versus State, which is 737 Southern 2nd 520, quote, the trial court had no special vantage point in reviewing this tape Based on our review of the transcript and tape, we conclude that the record evidence is legally insufficient to support the trial court's finding, unquote. To go to the point that, as I mentioned when I was speaking before, that there is case authority that stands for the proposition that when evaluating transcripts, this court stands on equal footing and can certainly look at two transcripts, compare them and make an independent evaluation as to whether or not this is in fact new testimony, which I respectfully submit that Dr. Omita's testimony, Odemark, when he testified in his trial testimony and presented this unobjected to testimony, that it was not new, it was not materially different. Now,
And counsel, I just going back to my previous discussion with you, you're saying that was raised to the lower court because you still have a responsibility to make that argument at the time of trial, correct? You can't just say, Judge, take a moment and you take a few hours, just read all the transcripts. You've got to present that argument. And I'm still struggling with understanding how I got the prejudice. I understand Judge Lambert hit that nail on the head. I understand the prejudice argument was clearly raised. I'm having a hard time seeing where we're raising this argument of the two opinion, Judge, this is not a contradiction in opinion, because what I'm seeing is what appears to be a concession on page 2307 of the record.
and again, Your Honor, I know what Your Honor is referring to. I think the concession was that the expression that the counsel used was, I can't tell you if it's materially different. I don't think it is. He sort of hedged a little bit.
Is the accurate way to say he just thought that was his weaker argument, so he gave it pretty short thrift, but then moved on to the prejudice? Not necessarily that he didn't preserve it, but just that he spent more time on the argument he thought was stronger.
I think that's a fair way of putting it, although honestly, I don't know what was in his mind at that moment. I believe, and I wasn't at trial, but I believe that when counsel provided the transcripts and said, I'm proffering them both, I think that he believed that it was a given that these were the same. I don't think that he questioned that. I think he did hone in on prejudice because I think, quite frankly, to use the colloquial term sandbagged, when this came up, I think he must have been completely stunned. I looked at the record. It appears at record 1748 and 9, which is the trial minutes, which is day 3 of the trial, appears to be when the issue of Dr. Odemark first reared its head. And this idea that, well, this is a brand new opinion and we completely were taken off track.
I don't know why it's doing that.
Is that a
Timer? This thing gonna explode? I'm just gonna stop that. I've never had it do that before. Is that a new thing? Ah, okay. Let me see if I can.
Sure.
It reminds me in trial court when I used to accidentally press the panic button under a desk with my foot.
There we
I
go.
was going to say is
Deputies would rush in.
Okay, all right. I got the alarm turned off. Thank you. That's a first. Go ahead, counsel. I didn't mean.
Of course, no, of course. So again, this was an instance where clearly there was no objection at the time the deposition was presented. And it's interesting because I hear references to counsel. It was just like another deposition, like any other deposition, but it was also like trial testimony.
I want to make sure I get one more question in for me before
Yes,
your
of course.
time expires. Assume that we think it is a different opinion, and assume we think Binger just does not apply. Trial courts can enforce their trial orders, and it was late, and they can exclude it because it was late, and they don't have to think about whether there was prejudice. The backup argument you gave me was, well, even if that's true, Judge, they didn't object to it at the time it was given. We stipulated it was a trial testimony deposition, and they didn't object. How does that opinion look? Tell us how we would write an opinion resolving the case on that ground in your favor.
Well, that is a fundamental principle of the necessity of a contemporaneous objection in order to preserve an issue as it relates to the admissibility of testimony. I think it's important. If this court were to say.
So there used to be a rule on testimony perpetuated for trial, and that rule is not there anymore, right? So what we have here is a deposition, occurring under the deposition rule, where the parties have stipulated it's going to be for trial, even though that's not really a concept embedded in the rules anymore. So that's why I'm asking, how does that opinion look? Where we say this was actually trial testimony, it wasn't really deposition testimony, and they didn't object at the time it was the testimony.
If the court applies it that way, then the court should reverse here because they waived the issue. How does it look if the parties agree in advance that this testimony is going in as if we were sitting in the courtroom, coming in at trial, and they lie in wait, they don't object, because they did object to other things. I mean, if the court were to go through that transcript, they objected, plaintiff's counsel objected to several points. So if we're going, yes, Your Honor. if we're going to take the perspective that this was trial testimony, right? And that therefore it should be evaluated under rules relating to trial, then there would have to be an assessment as to whether or not the attorney contemporaneously objected in order to preserve an argument that this was somehow an undisclosed opinion. That didn't happen. So to me, the opinion would be very clear. Plaintiff argues that this was improper testimony. However, because plaintiff failed to object and cannot demonstrate that they were prejudiced somehow, then the court should reverse because the testimony should have been allowed.
And we're way over time.
Is there something in the record that gives the details of the stipulation relating to that deposition?
I don't think so, Your Honor. And I don't recall anything that specifically went into that other than this understanding. But I do urge ultimately the court, whether Binger applies or not, to evaluate the fact, as Judge Lambert made clear, this is not a case where the plaintiff was prejudiced by some unknown, undisclosed opinion.
Counsel, I might stop you for just,
And I'm gonna-
keep
yeah,
it very short because I've let you go a little long. So,
Understood.
yeah.
So yeah, I'm gonna close on that. I think ultimately I would respectfully request the court reverse because we were prejudiced. The plaintiff would not have suffered prejudice had this been allowed to be presented. So I thank you for this extra time.
Thank
We
you.
asked to reverse and remand for a new trial.
Thank you both. All right. Have a good afternoon.